If you have a living trust and you set up that trust to have your estate avoid probate when you pass away, then you need to make sure you watch this video. First of all, congratulations on using a living trust. You've set up your estate in a great way to have your estate be as easy as possible for your loved ones to administer when you pass away. It's also a great way to have your helpers be able to take care of your assets for you if you become incapacitated. However, if things haven't been done correctly, then the trust won't work the way you want it to. So that's a major problem, and we're going to talk about that in this video. The issue is not having your trust funded correctly. And by funding, I mean the ownership of your assets and the beneficiary designations on your assets. If those are not set up correctly, then the trust won't work the way you think it will or you want it to. So let's talk about a couple of different scenarios. Let's say you have a trust and you own a home, some bank accounts, some investment accounts, stocks, vehicles, and you own those in your name as an individual. You created your trust and you didn't do anything with your assets. You continue to own them as an individual. When you pass away, then under that scenario, all of those assets will still have to go through probate. Having a trust doesn't mean your estate avoids probate. Having a trust that is funded correctly means your estate will avoid probate. So we've talked in other articles and other videos about what probate is, why it's used, but let's take a quick review. The reason why probate is needed in some estates is because someone owned an asset, let's say a house, when they passed away. Because they own that house, only the owner of a house, only the owner of a bank account, whatever the asset is, only that person can access that, can sell it. And if the owner dies, then no one can sell it. So a probate proceeding is going to be required in that circumstance. Someone, the executor named in the will, goes to the probate court and says, we need to open a probate, I need to be the executor. And the court appoints that person as the executor, giving them at that point the legal authority to sell the house, to transfer the house, to access the bank accounts, whatever. They have the legal authority because the court said so to do those things. So that's why we need to go to probate. But if you have a living trust, there's no need to have those assets go through probate, because what you need to make sure you do is own your home as trustee of your trust. Own your bank accounts in your trust. Own your vehicles in your trust. So if you pass away owning those assets, then you don't own them in your name, they're owned in your trust. The successor trustee that you've named in the trust then takes over, can go to the bank as trustee, the current owner of the bank accounts, and access those because they're the trustee of the trust. They don't have to go to court to get the legal authority. The trust gives them the legal authority. They can sell the house, they can access the bank accounts, they can sell the stock, transfer the vehicles, they can do anything with the trust assets because the trust gives them the right to do so. And there's no need to have any court involvement. So anything that you own, like real estate, bank accounts, stocks and bonds, vehicles, investment accounts, even a business interests, those should be owned in your trust. If not, those would have to be probated. Other assets like retirement accounts and life insurance, we're going to treat a little bit differently. You will not transfer your retirement accounts into your revocable living trust. If you did that, then you would have to pay income tax on the whole amount. The IRS would treat that as a withdrawal of the entire IRA, and you would have to pay taxes and maybe even penalties for that transfer. So that's obviously a very bad result. What we do instead is we have you change the beneficiaries on your retirement accounts so that the trust will be coordinating with that, either as the primary beneficiary or a contingent beneficiary, so that your trust will receive those funds at your death and then distribute those to your beneficiaries the way the trust is intended to. For life insurance, similarly, we have you change the beneficiary on the life insurance so that the trust is the beneficiary. What that means is the successor trustee would receive the death benefit from that life insurance at your death, would then use those funds to pay your expenses, taxes, any debts, and then distribute the balance of those funds with the rest of the assets to the beneficiaries the way that the trust instructs that person to do. So, to summarize, I think it's so important, and so many attorneys overlook this, and we see a lot of people come to our office who had trusts created by other attorneys and they don't have a properly funded trust. It's so important to have your trust be the owner of your assets or to be the beneficiary of your assets so that your estate will avoid probate, so that your assets will be handled appropriately by the right people in the most efficient way possible and without court involvement. So if you have a living trust, fantastic. You did a great thing in setting it up. Now you have to make sure that it's funded correctly. And if you have any specific questions about how to fund a trust or why certain kinds of assets are funded a certain way, and you'd like to talk to one of our attorneys about that, we'd be happy to help you work through those issues. You can give us a call or contact us through our website, and we will look forward to talking to you. Thank you.